Welcome to In Court, the podcast where we delve into the trials and tribulations of the courtroom. My name is Nina Tornqvist and I'm a criminologist at Uppsala University in Sweden. My research centers on the worlds of the legal professionals with a particular focus on emotion and legal decision making. I have observed criminal court cases in Sweden for almost a decade.
My name is Chloe Squires and I'm a PhD researcher at the University of St Andrews in Scotland. My work looks at the sentencing of individuals charged with terrorism offences, and I am observing court proceedings in England and Wales.
My name is Nicole Bögelein. I'm a sociologist and criminologist at the University of Cologne in Germany. My work focuses on institutional racism in court and terrorism cases. For several months, I have observed courtroom hearings on low-level offences in German district courts. In this podcast, we dive into complexities we have identified throughout our times observing legal proceedings to demystify what happens in the courtroom.
Today, we're going to talk about language in the courtroom. Nicole, you have found this was a crucial topic in your courtroom research. Can you explain why?
Thank you, Chloe. In the research I do together with my colleague Diana Rizzine on institutional racism in court, this was exactly what we found, that language is a crucial topic. And why is that? Coming from a sociology background, I'm aware of how important language is, how it's actually a symbol that we all use, that we can all relate to, and that we all co-create meanings with. And as language is actually the only thing we really have in court, it's the way to make yourself heard. You might bring in proofs. Almost all of it is verbal, and specifically for Germany, there is a principle that's called orality principle. So everything that goes into the court's decision has to be uttered in words. You have to speak it out loud. That's why a lot of things also need to be read out. And so it's important that everyone who is in the room can follow what's going on. And so Diana Rizzine and me, we went into the first court hearings without a specific idea what we were going to look at when looking for where can we see institutional racism. But a topic that caught our attention quite quickly was that of language, because if someone is racialized or seen as someone who doesn't belong, that's often also facilitated by them not being proficient in German as the language of the court, and having someone there who needs to interpret for them makes the conversation slower, gives them less opportunity to react directly and quickly to things. So we found that language is one of the most basic things that discriminates between people in the courtroom. And having said that, I'm now speaking about German or the court language, but that of course also goes for the language of the law, because it's often very complicated, hard to understand. And so you don't only have questions of being part or being proficient in German or the court language, but also a question of being proficient in law language and understanding what's actually going on.
Yeah, thanks, Nicole. I think what you point out, that language is always important for human interaction, is really important. But I think you also highlight that the language is even more important in the courtroom because of these two principles that you mentioned. The principle of orality, meaning that all evidence in court must be presented in court, but also the principle of immediacy, which in Sweden means that the court's judgment can only be based on the material presented in the courtroom. And these two principles really place a great emphasis on language and communication. So I think that's really an important base for the discussion here today. But you also said that you looked at this question through an institutional racism lens. Can you tell us why this is important?
Thank you, Nina. So one of the standing evidence from research is that mastering the local language is often seen as a proxy for successful participation in the culture, for having arrived to the country you live in, etc. So it's also often essential to create connection and to ensure social advancement. In court, only those who understand can actually defend their own rights and their interests. And people who are not fluent in the language of the court are therefore dependent on an interpreter. And that is really something that's specific to people who do not have a background in the country where the court hearing is held and who do not have proficiency in the local language.
Some of the cases that I've attended have used interpreters in the courtroom to help translate for the defendant about what's happening in the courtroom. How do you think this impacts the language that's used?
Thank you for bringing that up, Chloe. Interpreters are a very important group of people in courtrooms, and they are actually there to facilitate and to make it easier for those who cannot follow the local language enough to understand what's going on. But at the same time, interpreters are not invisible, and they are also not vocally silent. I mean, they shouldn't be, they need to speak. This image of the invisible and vocally silent interpreter as the perfect interpreter was brought forward by Berg-Seligson, somewhat sarcastically, you have to say, because interpreters are by no means passive. They take on different roles at different times, and I want to explain what I mean by that. Often interpreters assume a subordinate position in the hierarchized courtroom. They offer services. So they're there as servants, if you want to put it that way. And this is often reinforced by them being perceived as racialized others. Often they are part of the group the accused person is also part of. So in structurally racist Western societies, this assigns the interpreter an even more socially subordinate position beyond the concrete situation, because you're not just there in that minute, but all the history of your life and even the broader history comes with it. And this structurally weak position is actually opposed to their contribution to the success of the hearing. The interpreter's skill, their empathy, and also their understanding of legal aspects are key factors that determine whether those dependent on their services can participate, can make themselves heard, can understand what's going on. So any momentary lapse of attention or an unfortunate choice of words can lead to misunderstandings. And so, yes, the interpreter is there to actually make sure that the disadvantage that someone has by not being fully proficient of the local language is conquered at the same time by the need of them being there and by the physical embodiment of someone not being able to speak the local language enough.
So in my mind, the presence of an interpreter almost acts as a filter between the courtroom and the defendant and the courtroom. The interpreter is somebody that information needs to pass through. Do you see in your experience that the presence of the interpreter potentially shapes the trial in any way in terms of the information which is imparted to the defendant or imparted to the judge, or do you have any thoughts about that?
Absolutely, yes. A feeling I had, a gut feeling that sometimes things might not be passed on appropriately. Maybe something was missing. And we had an interview with a judge who was bilingual. He spoke Turkish and German. And he told us about one specific hearing where the accused person spoke Turkish and he had an interpreter there. And he realized how the interpreter was off all the time, how that person was always just a bit besides the point. So that altered the meaning of what was actually perceived by the accused person who was trying to make the best defense for themselves. And just because the judge could listen and understand what was going on, he then asked the question again to make them reverbalize it, to make them reword the sentences, etc. And that way he could make sure that the accused person could actually understand what was going on. But that made me wonder in how many instances that's not the case, because there are so many languages out there and only so many languages one judge can speak. So yes, I guess apart from all the high demands that interpreters have to follow, they have to be really good in their languages. Although interpreters need to get accreditation to be allowed to interpret in courts, still there's a lot that can go wrong. And if it goes wrong, there's a lot at stake.
That's so interesting because so much of what happens in the courtroom is based on subtleties of language. So when those subtleties are potentially misshapen, it's really interesting to think about the impact that has on the overall trial.
Yeah, and I was also thinking a couple of years ago, I did a study on institutional racism in Swedish criminal legal system as well. And we also realized how much impact language has, especially in the courtroom. And similar to what you said, Nicole, I think a lot of the legal professionals kind of viewed the interpreters as a necessary evil that they just needed to get by. But there were also a lot of frustration with the fact that the level of competence varied greatly between the people who work as interpreters in the courtroom. They were also identifying regional differences, having much harder time finding a good interpreter in rural Sweden compared to the bigger cities. But what I also thought was interesting, we did interviews with interpreters, and they talked about how they were treated as bothersome when they wanted to access forensic medical reports or other documents to be able to bone up the correct terminology and be prepared in beforehand. And I think that was also part of what we're talking about when we talk about institutional racism, that when they wanted to do their job, they were hindered by the legal professionals not being able to come up with either subtleties that you were talking about, Chloe, but also the legal professionals had experience with really crucial words that were misinterpreted in court, like, for example, what kind of weapon the defendant were using, which made the legal professionals question the plausibility or credibility of the victim's story. So language is really, really crucial. Like I mentioned, I did this study a couple of years ago, so I'm not so updated with the literature at the moment. But Nicole, you are writing about this topic right now. And what does the literature say about interpretation in the courtroom?
Thank you, Nina, for sharing the experience from your own research. I can completely agree on what you said, how for interpreters, they have to just react within the minute. They have to really be present, and they often don't know what is actually coming, what's going on in the case, because they're just invited to that. They need to have all the vocabulary at hand, be it a case of sexualized violence or be it a case of fraud or of theft. So it's really complicated for them. And also what you mentioned, the amount of people who speak a language, if it's a smaller language, then it's really difficult, even in bigger cities, to get an interpreter who is apt to do court translations or court interpretations. So that's also something that's a disadvantage for people who speak smaller languages. Something we saw a couple of times was that someone did not ask for an interpreter for their first language, but they asked for an interpreter for English. And we didn't speak to them about why they did that. But we discussed that in the team and thought maybe that had to do with them thinking it was less of a hustle for the court. So it was easier to get someone who spoke English, and they would rather make it more difficult for themselves and try to play the game of the court to be more pleasant in a way. But it might have other reasons, but that was something that we thought could be the case. But you asked about literature. Yes, there is quite some on court interpretation, and research points to that interpreting, first of all, represents an interruption. It gives time for reflection, dissolves the feelings of having been left without an answer. And so the one language that is shared by different parties usually excludes the second language party. So same language speakers communicate directly, while other language speakers need to make an effort. And parties that speak the same language often gain more attention in the courtroom than the other language speaking party, which is, again, a disadvantage that you can't really do anything against. There is research by Thomas Schäffer who examined interpretation in asylum hearings, and he saw that the German language transcripts that were fabricated later nurtured the illusion that it was possible to unambiguously render every foreign language into one official language. So everything seemed to be very clear and no doubt about it. However, parties sometimes complained about incorrect translations. For example, when interpreters would speak a different dialect or were members of a different regional community. And so you see that this ambiguity is there. It just doesn't show in the documents that are later used by the authorities. Schäffer describes the assumption that interpreters are able to break down language barriers in a quite good picture, I think. He describes them as being seen as postmen who would actually just deliver one letter from one sender to the addressee without changing anything in between. But that's from the nature of language. That's not really something we can expect. One last look into the literature I want to point out is a study undertaken by Aliverti and Seoige. They analyzed court interpreting in a criminal court in Birmingham in the UK, and they found that court staff saw people who did not speak the national language as failing to participate, failing to integrate into, and failing to have an interest in the local culture. And these assumptions were triggered by the presence of an interpreter. So the mere physical participation of an interpreter poses a hardship to those who are in need for them.
I really like the analogy of the interpreter acting as a postman for delivering a letter from one court actor to another. What it made me think of is the concept of remorse in the courtroom. So we know that remorse plays an important role in the UK context, at least, in shaping the way that the judge perceives the defendant in terms of rehabilitation and future risk, and that might have quite a reasonable impact on the sentence that's handed down. We know that remorse is also a very subjective and quite subtle emotion which is displayed and is often impacted by culture and gender and different kind of experiences. I wonder if you had any reflections or any kind of thoughts about the capacity of an interpreter to convey remorse from a defendant to a judge, given that we know that there's kind of a room for error in the cases you've seen, and remorse being such a subtle but kind of crucial concept in the courtroom.
From the Swedish perspective, when I've spoken with legal interpreters in court, they would say that the guidelines for them would be not to convey any emotional aspects of what is said. They're just going to say the words. So sometimes you're in court and seeing a defendant or a witness or the victim being really emotional, either showing remorse or being very sad or whatever emotion. There's a lot of emotion in the courtroom, of course. But from what I understand, the professional stance for an interpreter in court is not to be an actor. They should not convey the emotions. They should just say the words that they are saying, which is really interesting because there's a glitch between the first testimony giving in their first language, which you can feel the emotions but not really know what they are saying, and then the interpreter's interpretation, which is usually quite unemotional.
That's really interesting because it almost means that remorse can be lost in the translation between the defendant and the interpreter, and then posting that letter to the judge.
Absolutely, and that's also accompanied by the timely subsequence. Like the judge, if they were in a one language courtroom, then they would hear the witness saying something, and they would probably look to the defendant at some point, seeing whether they look sad or frightened or impressed by what the witness says. But this is something that's not possible for the person who doesn't speak the language, because they will only hear that maybe 20 seconds or 30 seconds later. But by that time, the language in the courtroom and what's going on in the courtroom has already moved on. So even if they are now doing their facial expression to show remorse, it's lost because the judge won't look to them now. So that's absolutely something that's among these subtleties of how quickly even 10 seconds pass, because there's always language in the courtroom. There's always someone speaking. There's never this break. And that's, as you say, something that gets lost in translation or interpretation, to be precise.
One further question I had is, I suppose, potentially more of a methodological question about how did you go about the research? How did you find out about the interpreter, and how did you research that? How did you employ that in your research methodology?
So while ethnographic research on racism in the courtroom is established in the English-speaking world, few academic studies in German-speaking countries have actually worked with courtroom observation in general. and even less with courtroom observation in the field of institutional racism. But some activist researchers have investigated specific cases. Justiz Watch has been monitoring lawsuits since 2014, together with another organization such as Reach Out and COP. And our partner institution, Justice Collective in Berlin, also an NGO, has been observing cases for a few years now. So we could go back to their experiences, read the material they had provided, and understand the techniques they had applied. And what we then did was we did court observations on minor everyday crimes, for example, theft or fraud or fare dodging, which are judged by a single judge at a regional court. So we sort of minimize the amount of actors present. If it's more than one judge and a lot of other people present, it's more complicated. So we really tried to boil it down and go for these simple cases. And we have so far 300 observed proceedings. Our observations were non-participant and open, and we visibly took notes. And language was really the first thing that proved to be something we should look into more. And with it, the interpretation process in court.
That's really, really impressive work. And I'm curious, what are your main findings so far?
So overall, what my colleague Diana Rizzene and me found is what we said was that interpreting is a systematic aggravating factor. Interpreters are additional people in the room. Their presence changes the social situation. They are physically there. They are persons who have an appearance, they're present, they're late, they're loud or quiet, their voice can be annoying sometimes. They are individuals who add a further level of interaction that entails collaboration, verbal and non-verbal, with those present. That's the judge, the defendant, the defense lawyer, the public prosecutor. The interpreter's voice can be pleasant, or it may be perceived as too loud or too quiet. By speaking up, an interpreter may help the defendant to follow the trial better, but at the same time, they might irritate the other participants. Maybe the public prosecutor is bothered by hearing another voice while they read out the indictment. So the need for interpretation also slows down proceedings, and it forces people to wait. Having an interpreter present changes the mood. Impatience and tension arise during interpreting, and also the volume in the courtroom rises noticeably. The other day, we were in a hearing where there were 2 interpreters because 2 different languages were needed. And it was actually quite difficult to follow, even as audience, who was saying what, because sometimes you couldn't make out which voice was now the one you were supposed to listen to. And yes, while there is technical equipment, in theory, in the practice of German courtrooms, they're not so equipped to have a specific booth for interpreters to make it possible for them to speak into a headset and it just being heard by the defendant. Usually they're present in the room, and so their voice is heard by everyone else. Also, parallel speaking drains concentration and patience, also for the judge, and it's important how they feel, because that might have an effect on the sentence in the end. So although interpreting ensures communication, and we would never argue for interpretation not taking place, but still it's the worst of good amendments, I guess, because also interpretation is communication through an intermediary. As we talked about before, the link between words and facial expressions is cut. Sometimes it gets lost. And there's also no opportunity for quick questions. So anything that's normal communication is really, yes, it's facilitated because you can speak at all with someone who wouldn't speak one language with you. But on the other hand, it's much more effort than it was if you were speaking the same language.
That is super interesting. And I suppose the use of an interpreter, while necessary, acts to fragment quite severely the process of legal proceedings, which can be quite a challenge. I really like the way that you frame that as a systematic aggravating factor, because it means that defendants who are using a interpreter already have a mark against them almost from the starting point. I wondered if you could elaborate a little bit on the interpreter as an intermediary. Did you have any key findings around that?
Yes, we did. We found that it was an ongoing question of who the interpreter actually belongs to. That was a topic that was somehow part of the room. As freelancers, court interpreters actually need the court as a client, and at the same time, they share characteristics with the defendants, language, cultural background. So this leads to a double expectation towards the interpreter. They could be perceived as siding with the defendant if the judge or the prosecutor were very critical. And still, it may be important for the interpreter to satisfy the court a little bit more to secure follow-up assignments. So in some interaction, there's also a tension between the interpreter and the defendant. By contrast, an important positive role of interpreters is the support they give by providing cultural context. They sometimes are seen by defendants as cultural brokers because they are someone else who understands their point of view because they share a cultural background. And so the defendant thinks, oh, maybe you as an interpreter understand how alien, how different I feel here, how I'm really lost sometimes. And yeah, that was also something that made it even more difficult for the interpreter because they feel this every party in the courtroom actually wants a piece of them and wants them to lean towards their side.
Almost as if they have to be neutral and on everybody's side at the same time. In the UK context, at least, I know that things like court sentencing remarks and those kind of data insights are really valuable, but haven't yet been used in AI. And they could be, and judges and the courts seem to be at the moment at least quite reticent to let that happen. I wonder, it's just an interesting point to reflect upon potentially how the use of kind of electronic means of interpretation could mitigate some of these challenges, but potentially pose others.
I did actually discuss that at a conference with other sentencing researchers, and we had some, exactly what you said, there are pros, there are cons. And then I had this discussion with a linguist who actually researches AI and the facilitation of translation and interpretation. And he said that we should take the luxury to only discuss things that are imminent because he cannot see that there was any AI that was going to be able to actually do the same way of interpretation and deliver the full service of a courtroom, of a human courtroom interpreter. So he said we need not worry about that too much. And at the same time, he pointed out that, again, that was going to pose a big disadvantage to people who speak smaller languages. Because as we already see, AI in English is so much better than it is in German, probably than it is in Sweden. So the more people speak the language and feed into the models, the better AI gets, and the fewer people you have who actually feed the model, the more difficult it is. So the problem is that AI will probably not be able to help in the most needed moments, because you would actually need AI if a language is hard to find an interpreter for, because there are so few speakers of it. And specifically for those cases, it seems quite unlikely that in the near future AI is going to be of help in these cases.
Potentially underscores the value, therefore, of actual interpreters in the courtroom, even if there are these challenges.
So, Nicole, listening to you talking about your research, I think it really demonstrates the asymmetrical power relation that is nested within the concept of institutional racism. And what we found in our previous research was that in Sweden, legal professionals tended to their own needs in relation to the use of interpreters. So kind of ignoring the fact that the need and the right to understand what is said in the courtroom is equally important for defendants, the crime victims, and the witnesses. And what we saw was that sometimes the proceeding judge would start the court proceeding before the interpreter had their technical equipment aligned, so they couldn't translate or interpret the first wordings of the court proceedings. But what I also think is an important aspect of this question of interpretation in courtroom is what resources the proceeding judge have to handle situations where they see that the interpretation does not work and where the language barriers just becomes a big problem. And when we did interviews with judges mainly about this, they talked about the time and the demands for efficiency, the time pressure and the demands for efficiency. So sometimes they would just go on with the court proceeding, although they realize that the defendant or the victim or the witness do not fully understand what is going on here. So they talked about a lot of improvised solutions. And I think that also relates to the knowledge that the court has beforehand. What is the language need? And that's my final question for you, Nicole. Do you think it's always clear what language is needed in the courtroom?
That's a brilliant question. Thank you, Nina. Who decides which language someone speaks is actually the question that is behind it, because often the judge will only have the file, the information that's provided in the file, and that is sometimes just a police officer writing down what they think the language is that someone speaks, or maybe they will just base their knowledge on the nationality of someone. And it was an extreme example. I'm still going to give it to point out that there are extreme examples. We had one judge who asked in the courtroom, the interpreter was present already, and he asked the defense lawyer whether the defendant who came from Guinea spoke French. And the defense lawyer said, well, no, actually, he speaks Fula. The judge then clarified that he had checked on the internet that Guinea had been a French colony, and he had therefore appointed a French interpreter. And the defense lawyer then repeated that the defendant actually spoke Fula and his French was poor. But the defendant's German was as good as his French, the defense lawyer said. And then the judge just put that aside and said, well, we don't have Fula here today, so French will have to do. And what followed was a really difficult interaction. You can't even say communication. Then at some point, the judge even spoke French, although still the defendant wouldn't speak French. So it became really complicated. And it reached a point where everyone in the room had the feeling that the defendant was actually the one being the problem because they wouldn't speak French, although everything was prepared for him speaking French. And that was when we realized how absurd the situation was. And so, yes, not always is the right language there. Not always does the interpreter speak the language. And it's not, even if you ask for an Arabic interpreter, there are so many dialects. So sometimes people won't understand each other, although they speak formally the same language, but the dialects are different. This brings irritation to the room. That again brings problems of slowing down the case because you have to find a new appointment and say, okay, this day is not going to happen. We cannot do the hearing today because we cannot communicate. So yeah, actually language is such an important and very subtle as well as in your face topic. I want to go back to what I said in the beginning. We cannot overestimate the meaning of language and the need of interpretation within a courtroom hearing. Thank you so much for discussing this with me and for listening to what Diana Rezene, my colleague, and I found out about this. So that's it for today's episode. Thank you for listening. Bis zum nächsten Mal.
Speak to you soon.
Vi hörs.